All right, so today we're going to skip the intro and we're going to jump right into this story. So by now you've seen this video.
You can show out and you can act a fool and you can make this difficult.
Or can my friend Judy take her?
Stop. Let me finish. Don't interrupt me. You can show out and act a fool and make the situation worse. Or two, you can calm yourself, ask your questions, and then help us get her stuff and walk her to my car. The option is yours, but either way, make no mistake, she's coming with me tonight.
Why?
Because of the treatment you've refused and because of the doctors.
I'm not refusing treatment.
Don't interrupt me.
Okay.
I'm so sorry. Can your sister go with her?
That depends. Depends on how you're acting right now. Okay?
Can she go tonight with her?
That depends. Again, you need to do what we're asking you to do, and then based on your cooperation, we'll dictate what direction we go.
But we need you to go ahead and start getting her
Yeah.
medications.
There was a mother out of Santa Rosa County named Joy Zuraff, and what you just witnessed was a home invasion and a kidnapping of her daughter Kenlee. I use the words home invasion and I use the words kidnapping deliberately because that's exactly what it was. There were a few red flags in this video that you need to look out for, but the most telltale sign was this specific part. Watch the sheriff's deputy.
I know it hasn't been for a long time.
Okay.
Alright, we're gonna have to pull ourselves together though, because we're gonna have to work on getting her ready to go.
It's kind of hard. You're taking my child away from me.
Alright, well if we can't pull ourselves together, then I'm gonna ask that you start getting her ready. Sometimes.
And where to? We're taking her to our
You don't have to answer those.
Okay.
Hey, ma'am. Ma'am. Sorry if we come inside. Okay.
Now, the reason that's so important is because you saw the two DCF workers, they just went right into the house without being invited. And of course, Joy was scared. The sheriff's deputy, he witnessed that and he knew that it was wrong. But before he entered the house, he asked, "Do we have your permission to enter the home?" What does that tell you if he had to ask that question in the first place? One, it tells you they didn't have a warrant and they didn't have any kind of a court order to even come to the home. Two, it tells you that he knew that before he entered that home, he needed the consent of Ms. Zuraff. He said, "Do we have permission to enter your home?" Meaning, he was trying to cover up the fact that the other two just barged into the home without a court order. That's a home invasion. But if you don't know the law and you don't understand the procedure surrounding this whole ordeal, what you saw might look like it's justified. It might look like it's legal. No, it was not. And the blame rests squarely on the DeSantis administration.
WrestleMania 3. Hey, what's up? Hey, stop. Get out of here. 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 Get out of here.
Now, DCF has been a child trafficking organization for a long time, but under Ron DeSantis, they've been incentivized to separate families and abduct these children. Under Ron DeSantis, these foster families are receiving grant money for taking in these kids. And this came to light after an investigation by an Orlando Sentinel reporter named Jeffrey Schweers. And me, myself, I didn't know that that was even a thing. I've always assumed that if you were going to adopt a kid, you already had the means to provide good quality of life for the child, right? I assumed that there was some type of screening process to determine whether or not you could provide for the child that you were adopting. Apparently, that's not the case, and they have incentive to take these kids because it's big business. You take a child and put them in this foster care system, and you get to select where the child is placed, right? This also means that you get to select where the grant funds are going. So when you have a group of kidnappers like these sheriff's deputies and the DCF workers in this video, they're thinking money. They know when we get this kid, the DeSantis administration is going to give us that grant. And that's the bottom line, money. Now, after this story broke, tons of other families came out and said that the same thing was happening to them. And I want you all to know, this whole thing that we're seeing with DCF just showing up at people's houses, taking kids and just chucking them into foster care, it is not legal, okay? The law does not work that way under any circumstances. Now, it happens a lot. It's often unchallenged, so you would assume that that's the way that things are supposed to go. But we're going to break down the law on this so I can explain to you exactly how this is supposed to go. Two things before we get started on that. One, I come from the prison reform community, right? And people advocating for prison reform, they call Chapter 33 of the Florida statute, Section 33, they call it their Bible, meaning everything that you should know about the Florida prison system is in that particular section of the Florida statutes. With that being said, if you are a parental rights advocate and you're looking for guidance on situations just like this, you need to make Chapter 39 your Bible, okay? And in this video, we're going to break down exactly what Chapter 39 says about this. And we're going to demonstrate that this was a home invasion and a kidnapping for a few other reasons, but Chapter 39 is the starting point, okay? But also, I want you to get familiar with all of the key players first. A Turkish doctor by the name of Golner Kam, Anne Gray, who was a former sheriff's deputy. She was the lady in the red shirt. And I read on Facebook that she had actually lost her job with the Escambia County Sheriff's Office for another incident involving a child. DCF Specialist Denise Kenlee, Sergeant Jeff Appling, a magistrate named Zachary Bolito, and Brooke. My name's Mo Dimash, and I'm a 2026 candidate for governor of the state of Florida. And right now I'm calling for three things. One, the immediate dissolution of DCF. Two, an executive order from Ron DeSantis directing the reunification of Kenlee and her mother Joy. And three, that Kenlee be brought back yesterday. Let's discuss. All right, so first, let's address this narrative that DCF can just up and take your children. Chapter 39 has all the information that we need, so let's start there so that you understand this statute and all of the rules through and through. Now, this statute is extremely long, but the relevant part is Part 3. This is the part that confers jurisdiction on DCF investigators and what they're allowed to do when they have to investigate the welfare of children. It's titled Protective Investigations. Now, I want to premise this by saying that the state of Florida has the best laws on the books throughout the entire nation. And quite frankly, we have the best statutes in the world. The problem is we have the worst people tasked with upholding our laws, and we have the worst people administering our laws. That being said, Chapter 39 is designed to keep families together, okay? It's not a bunch of statutes you need to look at and be worried about, oh, if I cross this line, something could happen, or if this happens, I have to be worried about that. No, it's designed for the safety and well-being of children. DCF is created under an entirely different statute, and it's under the direct purview of the governor. It falls under the executive branch. This particular set of statutes simply lays out the procedure. So it's important to note that abolishing DCF is separate and apart from maintaining these statutes. So let's take a look at section 39.301. This part talks about immediate on-site protective investigations. This means that this is what allows the goons that we saw in this video to immediately show up and investigate a report of a child being abused, abandoned, or neglected. Now, there's 6 circumstances wherein this is actually warranted. 1, the child is known or suspected to be the victim of child abuse as defined in section 827.03, or of neglect of a child as defined in 827.03. That's the child abuse statute that talks about aggravated battery on a child, torture, malicious punishment, or putting a child in a cage. I think it's pretty clear that none of that applies to this situation of Joy Zuraff and her daughter Kenlee. 2, the child is known or suspected to have died as a result of abuse or neglect. Again, inapplicable. The child is known or suspected to be the victim of aggravated child abuse. Inapplicable. A child is known or suspected to be the victim of institutional child abuse or neglect as defined in 39.01. and as provided for in 39.302 subsection 1. That section pertains to department employees abusing kids. That's more about institutional child abuse. Again, inapplicable. And finally, that the child is suspected to have been a victim of human trafficking. Again, inapplicable. So we can start this whole thing off by saying that the DCF workers and those 2 sheriff's deputies were not even authorized to be there in the first place. Now, there is a medical component. This is the part that gets misconstrued, and it makes kidnappers and people who abduct children believe that this is the type of situation that warrants the separation of families. It is their lack of understanding of the law that has caused all of this chaos because they don't know the law. Now that we know the law didn't even authorize any of those people to be there in the first place, it's critical. Now that we know the visit to Joy Zuraff's home was illegal, just the mere fact of them showing up in the first place, that was not authorized. We can skip the remainder of 39.301 because that pertains to the state attorney and criminal investigations and all of that. And we can go straight to 39.401. This is the statute they misconstrued. But the fact that they don't know the law, that is not Joy's fault. That is not anybody's fault but their own. So let's look at what they were relying on and how that turns this whole thing into a home invasion and a kidnapping. For real. Now, 39.401 is the actual statute that governs when they can legally take a child into custody. Typically, you have to file a petition in the court, a sworn petition in the court, before you even think about taking a child into custody. Under exceptional circumstances, you can take the child and then file the petition, but it would have to be egregious. And as we've already established, the 6 emergency circumstances that the law actually authorizes did not apply to this situation. Now, here's the target provision right here. Subsection B. A child may only be taken into custody by a law enforcement officer or an authorized agent of the department if the officer or authorized agent has probable cause to support a finding. Now, there are only 3 circumstances where they can actually take a child into custody. Number 1, that the child has been abused, neglected, or abandoned, or is suffering from or is in imminent danger of illness or injury as a result of abuse, neglect, or abandonment. That's the provision that they actually used in this case. But let's go over the other 2 just so that you have a full understanding of the totality of this particular subsection. 2, that the parent or legal custodian of the child has materially violated a condition of placement imposed by the court. This was before any court proceeding, so this one is not applicable. 3, that the child has no parent, legal custodian, or responsible adult relative immediately known and available to provide supervision and care. So now we've nailed it home. Somebody had to give sworn testimony pursuant to 39.401 subsection 1B1 that Kenlee was in danger of illness due to abuse, neglect, or abandonment. Now, the kicker about this particular subsection, when a child is taken pursuant to abuse, neglect, or abandonment when it comes to this perceived imminent danger of an illness, a DCF worker is not authorized to take that child. Only a law enforcement officer can do that, because the statute requires that when a child is taken pursuant to this provision, it's the law enforcement officer's duty to make a full report to the Department of Children and Families. It's not the responsibility of a caseworker or specialist or anything like that. The law enforcement officer has to do it. And that law enforcement officer has to explain why he delivered the child to the custody of those people. It's not the law does not authorize a DCF worker to snatch a kid and then make a report and just replace a sheriff's deputy. The deputy has to do it and then explain to the court why he did it, and then transfer the child to the custody of the DCF worker. That's the process. That's a safeguard, and that's pretty much what the law expects. But the law also provides that in situations where a caseworker does actually do this, they're required to sit down with a staff attorney for the Department of Children and Family and do an assessment. And this review is so that the attorney can tell the DCF worker whether or not there's probable cause to file a shelter petition, meaning General Counsel is the one who makes the final determination as to whether or not there was actually probable cause. And in cases where there is no probable cause, the law specifically states the child must be immediately returned back to the parent. Now, this is where everything falls on the attorneys who work for the state of Florida. If they deem that probable cause was sufficient, now they have to go to a court and file a petition within 24 hours to justify taking a child from the parent. This is known as a shelter hearing. Now, there's a few red flags with the way this whole thing played out as well, because I looked at the docket, what was available in the Santa Rosa County Clerk of Courts, and I didn't see any case filings for Joy for about 9 months between when they first took Kenlee up until that date. And in that case, there was a request for an emergency hearing. So if that 24 hours turned into 9 months, somehow somebody's got some explaining to do. And when it comes to a lawyer or a DCF worker actually saying that or swearing to the fact that there was probable cause to take Kenlee because she was in imminent danger of illness, somebody has to explain why they allowed the same circumstances that they swore to justify this removal to persist for 3 months. Because guess what? The same medication that they said Joy wasn't giving Kenlee wasn't given to Kenlee for another 3 months. So you took her because she wasn't getting this medication, and the whole time you had her for the first 3 months, you weren't giving her the medication either. Guess what? The law says something about that too. And for at least 3 months, they breached their own duties to provide the care that they said Kenlee needed. But the most important part of this statute, and what makes it a kidnapping, is this part. When a child is taken into custody pursuant to this section, the department shall request that the child's parent, caregiver, or legal custodian disclose the names, relationships, and addresses of all parents and prospective parents and all next of kin of the child so far as are known. You know why? Because separation of families is supposed to be a last resort under Florida law. And remember when Joy said this?
Can my friend Jamie take her?
Stop.
She was trying to give them the information necessary so that Kenlee would not be placed in foster care. There was next of kin. There was another parent. There were other relatives. They skipped the whole requirement that next of kin be alerted first and just took this child. And now that we know that this Trikafta was recommended by Dr. Golner-Kahm, and the fact that Joy was not administering this to her daughter, that was the reason, that was the justification for taking this child. And then we find out for 3 months, DCF didn't give her Trikafta either. Guess what that means? There was no probable cause, regardless of what they swore to in that petition. if they even filed a petition. The probable cause was gone. So guess what that means? Without that probable cause, when they walked into that house, that was a home invasion. Once the probable cause is gone, that whole house of cards falls. And nothing after that can be justified. Because if the lack of trifecta was enough to take Kenlee away from Joy, the lack of trifecta was probable cause to take Kenlee away from DCF too. That didn't happen now, did it? That word imminent is the one word that changes this entire situation. Because that one word imminent is the statutory language that gave what they thought was an avenue to take Kenlee in the first place.
Brand new, but it's a newer drug with a black box warning, shown to cause death, liver failure, all kinds of adverse reactions reported. They didn't even put the child on the drug for 3 months, almost 3 months after they took the child away. They didn't even put the child. They put her in a foster home, wouldn't put her with her parents or family members. She wanted the child to be placed with family members. Nope, we're going to place her with strangers in foster care.
But the fact that they waited 3 months to address this imminent concern means that that same concern wasn't imminent in the first place. Somebody lied. And it turns this whole thing criminal. Home invasion and kidnapping. That's just what it is. And it opens the door for civil rights concerns, civil rights actions, because these are civil rights violations. It brings in what's known as the constitutional question, the federal constitutional question, which means now Joy has a pathway to federal court to rectify this atrocity. And Joy is a brave mother because she went to the federal court. Now, from the outside looking in, when I was looking at this entire situation, I thought federal civil rights violations immediately. And I said, well, if she took the federal route, at least she'd be in good hands, because up in the Northern District, which is the federal district where all of this would fall under because of the location, in the Northern District, they got Mark Walker up there. And if you follow any of the federal litigation involving the state of Florida, you know Mark Walker is the one person Ron DeSantis is scared of. And I've been before Mark Walker. I've practiced before Mark Walker. And what I can say is this: if you are right and the law and the facts are on your side, you'll get justice. And all across this state, people who have raised challenges to a lot of the actions from Ron DeSantis, they take their federal cases to the Northern District and they're praying that they get Mark Walker on their cases, because everything about Ron DeSantis is unconstitutional. And Mark Walker is known to uphold the Constitution. That's just me from the outside looking in. So when I saw that she had actually went to federal court about this, she sued the judge in a case called Zuraff v. Duncan. And when I found that case, without even reading the filings, I said she's brave. And she did it pro se. And that fact alone tells you how much she loves Kenlee, because she's stepping into the lion's den, because you will always be punished for being a pro se litigant. Don't ever forget that. Whether you're good at it, whether you're not good at it, you will always be punished for being a pro se litigant. And against all odds, she went to federal court. So I was able to actually find this pleading that she filed. And now federal judges, they often get pleadings like this, but they get these pleadings. It's the litigant and the court looking past each other every single time a pleading like this arrives, because the average person believes that the federal court is there to protect them. Everybody truly believes in the Constitution, and they think that just by bringing something like this to the awareness of a judge is enough to get the ball rolling on some semblance of justice. That ain't how it goes, because most of the time the federal judges are worse than the state court judges. And her lawsuit was against the judge. Now, with this document, she's essentially saying this judge violated my rights. Let's talk about it. The learning curve when it comes to litigating in the federal courts, it's a steep one. And unfortunately, the judges are not there to hold your hands. The judges are not there to grab you by the hand and walk you towards the Constitution. The pleading requirements and the way that these complaints are framed take precedent over your value as an American, over your value as a human. They're not our heroes. And what this judge did, this magistrate judge, there's a distinction to be made, because magistrates are not real judges. And, here's a little crash course on the American judiciary and the constitutional framework behind these courts. First of all, the magistrate said that the judge is immune. Judges are not immune from everything. It typically requires an analysis on a case-by-case basis and really analyzing specific laws and determining when and where they stepped out of bounds, right? It takes a lot of forethought and a lot of planning to craft something like that properly. It can't be accomplished with a one-page document. That being said, this magistrate proposed what's called a report and recommendation to the district judge, and looking at the docket, it seems to have taken the motivation out of Joy when it comes to her fighting for her constitutional rights, because she didn't object. And like any other person who's new to this steep learning curve that is the federal court system, she probably thought that the magistrate judge cut her legs off. She probably thought that was the end of the case, and it wasn't. When a magistrate issues a report and recommendation, there's nothing final about it. You have to think of a magistrate as like a judicial assistant, essentially, to a district judge. And you're allowed to file objections if you think the magistrate got it wrong, especially as a matter of law. Joy didn't file an objection to that report and recommendation, so my assumption is that she assumed that the court had rejected her position. And the distinction has to be made. Judges, actual United States district judges, are created by Article 3 of the Constitution. Because essentially, according to our Constitution, the only real court we have is the Supreme Court. But, we have presidents who nominate these district judges to different parts of the judiciary in every state and through the circuit system as it's broken down. Magistrate judges are not a part of that at all. Magistrate judges are pulled in through a local nomination process based on the people who vet them locally. But magistrates, the office of the magistrate is created by an act of Congress, which makes them Article 1 judges, meaning everything that Article 3 says about the powers of a judge don't apply to magistrates. Why we even have them, I don't know, but I did go to the United States Supreme Court to try to get the Magistrates Act struck down, because a lot of magistrate judges try to be district court judges. And it causes all of these due process issues that make court proceedings unreliable because of these folks who lack jurisdiction or exercising jurisdiction where there's none. And it's my view that that is antithetical to the Constitution. We did get to the Supreme Court on that issue, but my cert petition was denied, unfortunately. But I was in good company, because on the same day they denied R. Kelly, they denied Elon Musk, and a bunch of other people who try to change the law out of a genuine concern for the founding principles that make our Constitution trustworthy, reliable, something to where someone like Joy can go into a federal court and not bend that learning curve and still get the justice that she's entitled to. We're not there yet. And it's probably going to be a while before we get there, because until we start electing responsible leaders with the knowledge base to understand what these laws are designed to do and making sure that they're actually upheld, observed, and properly administered, this is going to be a common occurrence. Should I be elected as the 47th governor of the state of Florida, the rule of law will prevail. And we're not going to be hiring anybody unless they take a crash course on what the Constitution is all about. Because without that Constitution, these state laws don't mean anything, especially when they are repugnant to the Constitution. The system has failed Joy on every level. And she wasn't lucky enough to get Mark Walker to preside over her case. But that doesn't mean it's over at the federal level, because she can always refile, but it has to be done correctly. And if there are any good civil rights attorneys up there in the panhandle, Joy needs your help. And I believe that that's one of the most unfortunate injustices we see in this nation and in this state, is when somebody has a good cause of action and justice is denied because of a learning curve. That has to stop as well. The DeSantis administration came out and defended the taking of Kenlee. As soon as the video went viral, DeSantis's Department of Children and Families tweeted that the child is no longer in imminent danger. but they pretended like they didn't watch the body cam footage. And it's always like that. It's not until something goes viral that they say, oh, we didn't see that part. It was the same thing with the young man who was assaulted by the police in Jacksonville. Oh, we didn't see when the officer punched him in the face. Well, why are we trusting you guys with any of this evidence if you're never going to review it? You will never get me to believe that they just now found out that Denise Kenlee and Ann Gray behaved like that in that video. I'm sure they got dozens of other videos with them behaving the same way with other parents. But since it went viral, they have to condemn it. Why? Because they thrive when corruption is in the darkness. Santa Rosa, I love you all. There's a planned peaceful protest where the community is going to stand by Joy and give her support as she fights for her reunification with Kenlee. And I must say, I am very proud of you guys. That's what community looks like. That's what loving your neighbor looks like. That's what standing up to tyranny looks like. And Santa Rosa, you guys embody what my campaign is all about. And I would be honored if you would allow me to serve you as the 47th governor of the state of Florida. Because it's about time your government embodies your values. And I promise you that as governor of the state of Florida, I will make sure that it will. I hope to see you all soon. Can't make any guarantees because I'm a blue collar man just like most of y'all. But if it is God's will, I will see you soon. I love you all, and I'll see you on the next one, because we might have to do a part 2 to this, because we also have to have a deeper discussion about medical kidnapping and this medical invasion of privacy, mandatory vaccines for the children, abolishing the vaccine schedule, health freedom for Americans. We need that. And under my leadership, it'll be done on day 1. There's much more to discuss here, and we'll be doing a part 2 on this discussion. I love you all, and I'll see you on the next one.